Hello everyone, welcome to the video recording of Week 2 Oil and Gas Law at the Center for Advanced Legal Studies. I am Professor Wynn. If you were not able to attend Week 1, welcome, and I hope to meet you live in Week 3. Due to tomorrow being Thanksgiving holidays, in Week 1, we decided to go ahead and have a video recording of Week 2. So let's get started. So welcome to Week 2. The learning objectives for this week is understand different kinds of interests in oil and gas by their special names, understand the rights and characteristics of each interest, and understand the means by which the different type of interests are acquired, and discuss and evaluate common disputes that arise between interests. Every class structure, what we'll do is at the beginning of class, we'll look back to what we learned in Week 1. We'll go over the major points. And also at the end of each week, we'll look forward to the following week, discuss what we expect to cover in Week 2. So, before we do a flashback to Week 1, let's see. Right now it's Wednesday, November 26th, around 1 p.m. Crude oil prices, spot prices are at $73.67 a barrel. The 12-month strip price is $74.04 a barrel. Natural gas prices, WTI, let me see here, Henry Hub spot prices are at $4.41, and MCF and the 12-month strip on gas is $3.93. In Week 8, we'll discuss more of the business aspect of oil and gas, and throughout the weeks leading up to that, we'll discuss points here and there in regards to the actual business aspect of oil and gas. So, okay, back to the slides. Flashback to Week 1. We were able to, I was able to introduce myself, and the students that were present were able to introduce themselves and why they were interested in oil and gas law. You know, the majority of students, I believe, lived in and around the Houston area, and again, Houston, 60% of the oil and gas companies are based out of Houston. So that's a tremendous amount, considering there's a lot of cities in the United States, and 60% are based here in reference to oil and gas law, oil and gas activity. Oil and gas law has its own set of terminology. One of the assignments in Week 1 was to look up and fill out that crossword, just to get your mind flowing, thinking about the terms, and we'll discuss those terms frequently throughout this course, so that by the end of this course, you'll be comfortable with using many of those terms. So, if I was going to make a chart, I'd split it up into 3 different categories: the mineral owners, the oil company, and the surface owners. Mineral owner, lessor, is a term. So if you own the minerals and you decide not to develop the oil and gas minerals yourself, you lease it to an oil and gas company. Kind of like if you have a house and you don't want to live in it yourself, you're the landlord and you sign a lease, residential lease or commercial lease with a tenant. So in oil and gas, when that happens, the person who owns the property, here the person who owns the mineral rights, executes an oil and gas lease. and they are called the lessor. Now, the oil and gas company, usually it's an oil and gas company. It could be a rich individual that can drill his or her own well, and they sign a lease. They become what's called the lessee. Okay, so it's a person or company that develops the right to the minerals through an oil and gas lease. So lessor, lessee, you use those terms whenever there's an oil and gas lease involved. Okay. Another term is grantor. Grantor. If I'm a mineral owner or a surface owner and I convey my property, either all of it or some of it, to another entity, I'm considered the grantor. Grantee is the person or company or partnership that receives it. Okay, so grantor, person conveying it; grantee, the person receiving it. Can you use the word grantor and grantee when it comes to an oil and gas lease? No, that's not proper. You should use lessor and lessee because we're talking about a lease. Okay. So, petroleum reservoir. So, what is the #1 rule for finding oil and gas? Well, you look for it in places where it's already been discovered, right? So, that's called developing oil and gas reserves. So, if there's been a lot of success in a certain area, certain field, the likelihood of more oil and gas being found in that area, field, is there's a greater chance of finding that versus a new area. Okay, so if you're going out and trying to find oil and gas in an area that's never had oil and gas development or successful oil and gas development in the past, that's called exploration. So the term developmental versus exploration, those are used quite frequently in our industry. Again, I work for a company called Pintail Oil and Gas. We're not an exploration company, really. We stick to the safe rule, which is find it where it's been discovered already. Whereas the majors, we call them the majors. The majors are like Exxon, BP, Shell. Those guys, those companies, they have the funds, they have the manpower to go out there and to explore for oil and gas where it's never been developed before. So petroleum reservoir. Reservoir is kind of like think of a pool in your backyard. You know how much water is in that pool. Well, what we're trying to do is we're trying to find these pools of trapped petroleum products, being oil or gas, and so that's the goal, to find it and then produce it. Okay, so these are this picture that we're looking at. It shows 4 different types of petroleum reservoirs or traps. So moving on. So shale plays in the U.S. So a long time ago, being let's say 20 years ago or less than that, even less than that, developing or producing economically oil and gas from shale, a type of shale rock, was not very economical. So, people didn't do it. A lot of experts at that time, because of the technology at that time, I believe that we couldn't or we shouldn't produce out of shale because, again, it wasn't very economical. So with new technology such as horizontal drilling and fracking, producing oil and gas from shale has become more economical. So we'll discuss more about that, the mechanics of that later on during the semester. But there's been a big boom, right? So hopefully many of you have heard about the Barnett Shale, the Eagle Ford Shale, the Bakken, and the Marcellus. Those are all creating a lot more jobs in the region, a lot more oil and gas being produced in the lower 48 states. So, I guess the benefit of drilling and producing technology is, look, we have a lot more supply. We're doing things smarter, cheaper. We're creating new jobs, and during the process, we're also finding better ways to protect the environment as much as we can while developing oil and gas out of these areas. So let's review the basic concepts of contracts, okay? The basics of contracts. Now, I brought this up at the end of class last week. So when we're talking about oil and gas, okay, we're considering it as what's called real property, okay? Oil and gas in the ground is considered real property. So what other things are real property? Like your house, your land. Those are all real property, okay? Your right to easements and right-of-ways, those are all real property, okay? So oil and gas in the ground is considered real property. It's governed by the laws that also govern real property. So just please keep that in mind. Now, you know, once it's produced already, once it comes out of the ground, then becomes personal property. But we're not going to, just for the purpose of this class, okay, we're going to consider oil and gas as real property, okay? All right, because we're trying to figure out who owns it, how it's transferred, and how it's developed, okay? So during all those phases, oil and gas are still considered real property, okay? All right. So oil and gas leases, the different types of deeds, like a quitclaim deed, a warranty deed, special warranty deed, okay, joint operating agreements, farm out, farm in agreements. These are all different types of contracts that are relevant in oil and gas law, okay? And again, oil and gas is real property. So I'm stressing that a lot, and there's a reason for that, okay? So let's, before we move into specifically oil and gas, let's first discuss the 3 required elements of a contract, okay? So first of all, you have to have an offer. Party A makes an offer to Party B, okay? Then there is an acceptance of that offer, okay? So offer and acceptance, and then you have consideration. Now, the word consideration, an easy example of consideration is money. I offer you $10 for your hat. You accept it, and I give you $10, okay? So there's the offer, there's the acceptance, and there's the consideration. Now, consideration doesn't have to be money. It could be something else. It's got to be something of legal value, okay? So just know that money is not always consideration. For example, in gift deeds, for my love and affection, that is considered value, okay? That's consideration language that's found in gift deeds, okay? That's an example. Okay, so offer acceptance and consideration. Now, so there's a third prong or third branch or third element to this. It's no defenses of formation. So examples is illegal, insane person, intoxicated person, duress, coercion. So let's go to my example again. I'm offering you $10 for your hat, okay? And I offer it to you, and you accept it, and I give you $10. So 1 and 2. But then, if you look at the bigger picture, I had a gun pointing at you when I made that offer to you, okay? That's illegal, right? Or you were under duress, okay? So that's not a legal contract, okay? Or, you know, you were, hey, I know you're really drunk, okay? I love your house, so I'm offering you, you know, $100,000 for a house, and your house is worth a lot more. You accept it. I write you a check right then and there for $100,000. You take it. Do we have a contract? No, because you didn't have the mental capacity at the time, and I knew it for you to enter this contract, okay? So these are the basics of any contract, okay? Regardless if it's real property, personal property, it doesn't matter. These are elements that must be satisfied, okay? So now, contracts in real property, okay? Again, oil and gas is real property, okay? So the elements that we talked about earlier in any contract, those still apply, but in real property, there's additional requirements, okay? So now we're dealing with real property. Remember that oil and gas in the ground are considered real property. Excuse me. Elements essential in contracts such as a deed that deals with real property. Okay, so here we go. So under the statutes of fraud, all contracts dealing with real property must be in writing. Very important. Okay, all contracts dealing with real property must be in writing. So in other words, all contracts dealing with oil and gas must be in writing. Okay. Remember, in writing was not an element that we discussed that's required in all contracts. Okay, that wasn't part of 1, 2, and 3 in the previous slide. Some contracts could be verbal. Okay, but in oil and gas law, all contracts must be in writing. Okay. Now, so now you have a sheet of paper. Okay, your contract is a sheet of paper or sheets of paper, and on that paper it must contain words of grant. And words of grant, for example, are we grant and convey to you, John Doe as seller grants and conveys to so-and-so, okay? So it must contain words of grant. So next element, you have to have a competent grantor. So it's common that siblings contest the validity of a deed from an elderly parent to one of the siblings, claiming that the elderly parent did not have the mental capacity to competently make the grant. So you'll see this, and whenever you're talking about money, and sometimes there's a lot of money involved in oil and gas, and oil and gas rights are passed upon. It could be passed upon from grandparent to parent, to child, and so whenever one of the siblings realizes, hey, my parents gave all the mineral rights to my brother and sister and didn't give me anything. There's something wrong with her. I was a great kid. I was, but why didn't I get anything? So. Maybe they're either under duress or they were tricked into it to sign something. So I'm going to challenge their mental capacity. Maybe something was going on. They were sick. They were medicated. Who knows? Okay, so this is frequently contested in the courts. Okay, hey, the grantor didn't have the mental capacity, right? So. Okay. Identified grantee. So in oil and gas law, okay, so I have oh, and this again, this applies to real property. So this could mean a house, the land as well. Real property, all real property must be in writing. That includes oil and gas, but it also includes surface. So let's say I own the Galleria, okay, and I convey this to John Smith, and that's all I put. Well, there's a million John Smiths out there, okay? You know, the grantee, the person receiving it, remember, I'm the grantor in that situation. Excuse me. The grantee must be identifiable. I can't just say John Smith, okay? It's too common. Maybe if I put John Smith and his address, okay? So, all right. And again, it's got to have that consideration language, okay? It doesn't have to have, let's say John Smith paid me $1 million for the Galleria, and I accept. There was an offer, the acceptance, and I paid him. He paid me $1 million for my right to the Galleria. Now, in that deed, in that writing, because again, all real property must be in writing. It doesn't have to say that he paid me $1 million. It doesn't have to say that in the agreement. It just has to say, and you're going to see this in a lot of examples that we use throughout the semester, that consideration language was put in there. So, very common is for $10 and other valuable consideration. Now, does that mean he paid me $10 for the Galleria? No. It just means, hey, look, we understand laws that relate to real property, and one of the requirements in order for this contract to be valid is it has to have words of consideration. So that's why we're putting this language in there, okay? It has to be in there, but I know I don't have to put the exact amount that the grantee paid for it, okay? So just know that, just understand it for consideration. So, and we'll look at examples throughout the semester. Contain an adequate description. I put a little asterisk by that, okay? A common person must be able to determine the land that it is being conveyed. This is the #1 failure, meaning the #1 reason why courts have determined why a contract is not valid, okay? Because the description, meaning what are we describing here, okay? I can't just say, I'm selling to you my land. Okay, that doesn't describe the land. You got to have an adequate legal description of what is being conveyed. Okay, so and a lot of times people are sloppy, or they cut and paste a previous sloppy work, and so again, an adequate description is very important. Okay, and again, we'll discuss this more throughout the semester. Okay, must be signed by the grantor. Now, #7 doesn't say must be signed by the grantor and grantee. Okay, it must be signed by the grantor. So if I'm the one conveying it to you, I have to sign it in order for that contract to be valid. It makes a lot of sense, right? Now, does the grantee have to sign it? No. But can they sign it? Yes. A lot of times we require both parties to sign the document, okay? It just tells the world that, hey, the grantee has read this document, understands what they're buying, okay? All right? You know, sometimes you could sell a liability, okay? Like I have a oil and gas field, and there's no more producing wells on that field. It's just a mess out there. And so I want to sell it. I just want to convey it to somebody, okay? So who's going to want that field? It's just a nightmare. They're just going to have to clean up stuff. So the grantor has to sign it. The grantee does not have to sign it, but a lot of times we ask for both parties to sign it. Now, #8, be delivered to the grantee. So imagine a sheet of paper in front of me, okay? It's in writing, because oil and gas relates to real property. I've identified the grantee. I have words of consideration. I have an adequate description. I sign it, but now I have to give it that sheet of paper to the grantee. Okay, I have to deliver it to them. Now I have a valid contract in oil and gas law or in and real property. So, question number 1. Okay, the head accountant asks you to make sure that the grantee also signs the deed in order for the deed to be valid. Is he correct? Okay, so you're helping me out in our land department here. We want to sell a piece of property to somebody, and the accountant comes in and he says, "Hey, you make sure the grantee signs." Is he correct? Okay. No, he's not correct. Okay, grantee does not have to sign it in order for it to be valid. All right. He should stick to accounting. He is not correct. Next one. The head accountant again. Here he goes again. Asks you again to make sure that the deed is a warranty deed in order to be valid. Is he correct? Again, no. As you'll see, there's several different types of deeds. Okay, there's a warranty deed, which is also known as a general warranty deed. There's also a special warranty deed, and there's a quick claim deed. So there's several types of deeds, and so you just don't have to have a warranty deed in order for it to be valid. Okay. Now, this is very important. Okay. It says, let's start with the deed. Hello, human. I'm a cat. Okay. Now, why am I putting this picture up here? It's obviously not a cat. It's a dog. Okay. Now, what is my point? My point is, whenever you look at an instrument, okay, it might have the word warranty deed written on the top of it. Okay. Now, does that make it a warranty deed because the title on the top of it says warranty deed? Absolutely not. Okay. It's the content that counts, and a lot of times, the content is not what the heading says it is. Okay. So remember, legal contracts don't always trust the headings. You have to read the content to fully figure out what that instrument really is. Okay. So headings are great. They help you to figure out what you're about to read, okay? But they're not always accurate, all right? And so if the heading and the body do not correspond, courts have 100% stated that it's the body of the instrument that counts, okay? So read the instrument. Okay, read carefully. Read the documents carefully. Don't fall for the statement. It's a standard document. So, you go into negotiations with somebody, okay, for your company, and they just hand you a sheet of paper, and on the top it says, let's say, general warranty deed, and they say, hey, this is a standard document that we always use. Okay, don't fall for that. Okay, you can add so many different provisions to a document that if you think in your mind that, hey, it is a standard document, you're going to miss something, okay? Just read every word carefully. Pay close attention to what is being conveyed and reserved, okay? What's not being conveyed to you. So, very important. Attention to detail is what separates the great from the rest, okay? So, attention to detail. Okay, so sovereignty of the land. I would ask if this is class, what is this? So this is this picture represents the Six Flags over Texas, right? So when did mineral rights start? Remember, the United States is a very unique country where it allows for private citizens, private companies, private partnerships to own mineral rights. No other country is as generous and the laws are the way the United States allows for again, individuals, partnerships, companies to own mineral rights. So at one point in time, each piece of land was owned in Texas. Let's stick with Texas. Was owned by one of these entities. Okay, and these entities granted land to an individual. Okay, so whenever we say, whenever we're going to research title, beginning from the sovereignty of the land, that means from the time the whatever one of these entities first started to convey land out to an individual. Okay, that could have been in Texas, 1880s. Okay, it could be in the early 1900s. Okay. So here is a sample deed from sovereignty. All right, so this is pretty old here. This is from March 20th, from 1901. Let me see if I can highlight this for you. There we go, March 20th, 1901. This is from the governor of the state, okay, for $1,246.36. So let's review the parts of, is this a valid contract in real property? It's in writing. There's words of consideration. The grantor is here, and he's conveying it to I.D. Polk. Okay, grantee. We're assuming John Connolly is competent. Okay, and not under duress. We're assuming it was given to the grantee, delivered by the to the grantee. It was signed by John Connolly. Okay, so this is just a portion of a deed from sovereignty. Okay. Okay. Let's see, one second. Okay. So, okay, this is going to be very important for you to understand. Okay, the mineral estate and the surface estate. Mineral rights, surface rights. Mineral rights, surface rights. For a lot of people who've never studied oil and gas law before, they do not understand how you could own the surface but not own the minerals underneath it. Okay? In Texas and in many other states, okay, those two rights could be severed or split up. Okay? Just because you own the surface doesn't mean you own the minerals underneath it or the rights to the minerals underneath it. Okay? Are there people that own both the surface and the minerals? Yes, there's still a lot of families that still own that. Okay? So, at the beginning of time, so sovereignty of the land. Okay? There are some exceptions to that, and we'll talk about this later on during the semester, but we're just trying to keep it basic right now. So when Connolly gave it to that grantee in the deed we just looked at, the grantee now owns both the minerals and surface estates. Okay, it's called a fee simple estate. It's the highest form of ownership in a state of land. Okay, that means you own the phrases from the heavens to the center of the earth. Okay, so if you own something in fee simple estate, you own not just the land you're stepping on or your house is on, but the air above you and everything below you. Okay, that's called fee simple estate. Okay, so when the ownership of the mineral rights and surface rights are transferred to different owners, okay, so the property rights have been what's called severed. The result is a separate mineral estate and surface estate. We will discuss these different property rights in week 3. But let's give examples. So I own the Galleria. I own it in fee simple, meaning I own everything from the heavens to the center of the earth. Okay? But somebody just says, hey, you know, I would love to buy the Galleria, which means just the surface. Okay, he wants to buy the buildings and everything on it. And you know what? I want to sell it. Okay, but look, I want to keep the mineral rights. Just in case one day they find oil and gas underneath it, I want it. Okay, I'm not willing to sell the minerals. So my fee simple estate, I'm going to convey the surface rights away to another party, to the grantee. And I'm going to keep the mineral rights for myself and for my family, this generation, and many more to come. So now, in this deed that I convey to someone, they're just going to get the surface rights, and I'm keeping the mineral rights. Now, this is not fee simple estate anymore. One party, one owner owns the surface, and one owner owns the minerals. Okay? And whenever that happens, it's called the estates have been severed. So here we go. So question. So Farmer Davis owns 420 acres of land in fee simple. Does that mean Farmer Davis owns surface and minerals below the surface? Yes. Okay, fee simple. Farmer Davis conveys in a deed to City Slicker all the oil and gas produced and saved from 420 acres. Is it a correct statement that the mineral rights have been severed and conveyed to City Slicker? Okay, we're going to discuss this a lot more throughout the semester, but how you reserve or keep for yourself and how you convey oil and gas, you got to use the correct language, okay? There's a thing called royalty and there's a thing called mineral rights, okay? Those could be two separate things. So in this case, I wrote down in quotes all of the oil and gas produced and saved from the 420 acres. The language that I underlined, that's not mineral rights. That's called royalty rights. And I wanted just to briefly introduce that concept to you right now. Okay? And we'll discuss this more later on. So the answer is the royalty rights, not the mineral rights. But again, don't worry, we'll discuss this more throughout the semester. Okay, let's take a quick break and come back to the video. Okay, welcome back from the break. Let's continue. So conveyance of real property. Okay, so so real property is exchanging hands like a bucket, water bucket. That's moving from one person, one entity, to another person or multiple people. So conveyance of real property. Let's talk about the different types of deeds. And remember, that's flashback real quick. Speaking of Texas, at one point, sovereignty of the land, the government who was controlling the land at one time started conveying out pieces or tracts of land to an individual. That individual now owns it in fee simple, meaning both the surface and the minerals. So let's talk about different types of deeds. Different deeds are many of you should have already taken real property. So deeds are just instruments in which one person conveys his or her or their rights to real property to another person. So it's going from a grantor or grantors, O-R-S, to a grantee or grantees, okay? So grantor to grantees. And, okay, so first type of deed is a warranty deed, also called general warranty deed, okay? That's the highest form of conveyance. Grantor warrants that he or she owns the property, free and clear, no liens, and has the right to convey. So when you're reading this instrument, remember, even if it has the word different headings on top, what you're looking for is keywords is I, John Doe, grant and convey. And in the warranty, there's a paragraph that contains language of where the grantor warrants, guarantees certain things. So you want to see the word warrant and defend. Okay, those are very key words to help you identify, hey, this is a warranty deed. Okay. The warranty deed, whenever you're buying a piece of property from somebody, now could it be that that person doesn't own the property and is just trying to convey it to you? You know, just like I don't, you know, I can try to sell you the Galleria. Do I really own it? No. But if you're gonna give me some money for it, consideration for it, you want some guarantees from me. Okay, you want for me to warrant and defend the title, meaning, hey, I own this and it's free and clear, and I'm conveying it to you. Because if it ends up not being so, okay, that I own it, you're going to want your money back, okay, and maybe some additional damages that you've incurred. So a general warranty deed or / warranty deed is the highest form of protection, okay? The second type of deed that we're going to discuss is called a special warranty deed, okay, special. Now, okay, so if you think of which one provides me the most protection as a grantee, as a buyer, it's a warranty deed. The next level, which provides me some protection but not as great as the warranty deed, is called a special warranty deed. Similar to a warranty deed, but the grantor is only limiting his or her warranty of acts, claims, and demands by and under the grantor. For example, in a warranty deed, grantor is granting that there is no lien on the property. Okay? When I'm selling it to you in a warranty deed, I'm saying, hey, look, there are no liens in this property. All right? I'm conveying it to you free and clear of no liens. Period. In a special warranty deed, one of my the slight difference is, hey, look, ever since I acquired this property, I have not placed a lien on it or have caused a lien to be placed on this property under my watch. Okay, I don't know about the people that have owned it before me. Okay, so in a special warranty deed, that's the difference between those two types of deeds. Special warranty deed is to look, this is strictly, I'm warranting strictly what happened to this property under my watch, okay? And anything else in the chain of title, I'm not warranting, all right? So the grantor is warranting that he or she did not encumber the property with a lien. So words that you should look for to determine, hey, is this a warranty deed or a special warranty deed? Special warranty deed has by and through and under the acts of grantor, only the grantor. Grantor and the warranty language is grantor and convey with special warranty deed. Okay, special. When you see that, that just means, hey, look, I don't know what anybody else did, but once I got it, I'm warranting that that I didn't, you know, put any liens on it. Okay. All right. So here's an example in a $100 million deal. Big oil company is buying oil ranch from Mr. T. The deal's worth $100 million. Big oil man lawyer wants a warranty deed from Mr. T. Mr. T himself had just received oil ranch as a gift from his grandmother. Mr. T never had a title check performed on the land. Mr. T is only willing to assure Big Oil Man that since he acquired the oil ranch, he has not done anything to encumber the title of the land. See, you know, Mr. T really wants that $100 million, and he wants to keep it, okay? And he just received it as a gift from his grandmother. He's not going to want a warranty deed. To grant a warranty deed, okay, to Big Oil Company. In this scenario, Mr. T is the grantor, Big Oil Company is the grantee. Okay, this is buying of land. It's not an oil and gas lease. So, Mr. T never did any research, so he's not sure what his grandmother did or anybody else in the chain of title did to that land. So he just says, hey, look, I know what I did to this land, but to Oil Ranch, but I don't know anybody else. So I'm only willing. You want it? I'll give it to you, but in a special warranty deed. Okay? And of course, that's a lot of money. Big old man's lawyer is going to want a warranty deed. So, so there you have it. That's an example. Other deeds. Another deed is called a deed without warranty. Okay. Don't confuse this with a quitclaim deed. Deed without warranties, I don't see it too often. You mainly see a lot of warranty deeds. You see a lot of special warranty deeds, and you see a lot of quitclaim deeds. But deed without warranty, I don't see that much. But just know that grantor states that she has title to the land, but will not provide any additional warranties. Okay. And the language you should look for, it contains language of grant, sell, and convey, but does not mention anything in it about warranty whatsoever. Okay. Next thing, quitclaim deed. We learned this a lot. Okay. Grantor is not claiming to own any title of land and is not providing any warranties. Okay. Somebody knocks on my door and say, Professor Wynn, I want to buy the Galleria from you, Mr. Wynn. And I have no idea that I own it or any part of it. Okay, I don't know. And they said, look, we did all the title search. Here's the evidence. And you own it, and we really want it, okay? And I'm going to say, okay, I'll sell it to you. But again, I'm not claiming that I own anything in the Galleria, or I'm not going to give you any warranties. Okay, if you're going to pay me, I'm going to convey it to you in a quitclaim deed. All right, and if they really want it, they'll accept the quitclaim deed and they'll give you your consideration. All right, so if they find out a year from now that hey, we messed up, Professor Wynn does not own anything in the Galleria. Yeah, but I didn't warrant anything, and you know, I told you guys I wasn't sure what I owned, so I don't need to give the money back. Okay, so quitclaim. So keywords in the agreement. So when you're reading the agreement, look for words such as quitclaim and assigned. All right, so those are keywords you need to look for when you're reading these instruments to determine what type of deed it is. So if you see quitclaim, you know it's a quitclaim deed. Okay. So here's deed 1. Let's review it together. Okay. So grantor. We are reviewing the elements of a contract and real property. There's a grantor. In consideration. Here we go. For in consideration for the sum of $10. Is that what he really got? $10? No, probably not. Okay. Again, you don't have to put the exact amount that was paid for, or what deal you came up with. Just make sure that the words of consideration are in there, because if you don't put any words of consideration, that contract is not valid. Okay, courts will throw it out. Okay, paid in hand by John Swoboda and Frank Swoboda, both in Victoria County, so grantee. And this whole instrument's in writing. Okay, you can't say. I can't say I'll say the Galleria verbally, and you say I accept, and you give me $1 million, and we walk away. We're done. No, it's not in writing, and it relates to real property, so it has to be in writing. Okay, contains words of grant. Acknowledge he has granted, bargained, sold, and conveyed. There you go. Those are words of grant, and a property description. And here's a good property description of what's being sold. Okay, so I'm going to buy 203.5 acres of land, et cetera, et cetera. Okay. Deed Part 2, warranty language. Let's read it. Okay. To have and to hold the above described premises together with all in singular the rights and appurtenances thereto and anywise belonging unto the grantees herein, their heirs and assigns forever, subject only to the matters herein set forth, and grantor does hereby bind himself as heirs, executors, and administrators to warrant and forever defend. Okay, Here's some warranty language. What type of deed is this? Okay, look back at the previous slides. Warrant and forever defend. We know by this language it is a warranty deed or / general warranty deed. Okay. Here is it's signed by the grantor. Does the grantee have to sign this too? No, the contract law doesn't require that. Okay, but it does require for J.R. Locke to deliver it to the grantee. Okay, here's the next example, D2. Let's do another one together. So the heading says quitclaim deed. Are we going to be fooled by it? Let's make sure we read everything. Okay, don't be fooled by the title. So it says it's in writing. Grantor is here. Marie Cheatham, wife of Daniel Cheatham. Consideration language. Okay. In consideration to establish community property. See, it doesn't say a cash amount. Okay, this is value. They're establishing community property. Conveys and quitclaims. Oh, here's the conveyance language. Most likely, this heading is correct. And then to the grantee, it describes legal description, and it's signed by the grantor. Okay. All right, so let's go back to history again. Sovereignty of land. Let's say state of Texas owns a piece of property, conveys the first 100-acre tract out to me. Now I own 100 acres in Harris County. I own it in fee simple estate, meaning I owned both the minerals and surface from the heavens to the center of the earth. Okay, now I'm going to convey this 100-acre piece of property to somebody else. Okay, so I'm the grantor, they're the grantee. Now, unlike other properties that you convey, okay, mineral rights, if I want to keep it, Texas law requires me to specifically state in that instrument that I'm keeping it. I'm reserving it for myself. Okay, I'm reserving it. If I don't put that into the deed, it goes. My mineral rights goes away. It goes to the grantee. Okay, this is a very important concept that time after time people forget to do. Okay, and once it's gone, it's gone. You can try to buy it back, but that's up to the new owner as to whether to convey that back to you or not. So, you know, this is a unique concept because we're used to, okay, if I'm going to sell you X, Y, and Z, in order for you to get it and it relates to real property, I have to list X, Y, and Z. If I just list X and Y, you're not getting Z, right? But mineral rights are different. Mineral rights, if I own the minerals and I convey that property to you, and I don't list that, hey, I'm reserving my minerals, I don't need to list it. If I own it and I own mineral rights and I don't reserve it, it's going to you unless I reserve it. Okay? So again, extremely important concept in oil and gas law. Mineral rights must be specifically reserved by the grantor, or else the mineral rights will be conveyed to the buyer. In other words, if grantor does not specifically state that he does not or she does not intend to convey the mineral rights, the law will treat the conveyance as selling everything that he or she owns in that property. Here's an example. Example of reservation of mineral rights. So reservation and exception to the conveyance and warranty. For grantor and grantor's heirs, successors, and assigns forever. Remember, grantor is the person conveying something in this deed. A reservation of all oil and gas and other minerals in and under that may be produced from the property, including all executive rights. So this is a very good reservation. So the grantor now is conveying something else, probably the land, the surface, and reserving until himself or herself all the mineral rights. Okay, so this is a very good reservation of mineral rights. Okay, here's 3A, B, and C, and we're supposed to read it and let me know if it's a warranty deed, is it a special warranty deed, or is it a quitclaim deed? or is it a deed without warranty? Here, let's do the A. The grantor, the consideration of $100,000 to the grantee. Does hereby remise, release, and quitclaim. There we go. See, so it's quitclaim deed. Let's do letter B. Grantee, successors, and signs. Hereby binds grantor and grantees, successor, and signs to warrant and forever defend. Again, look at previous slides to look for keywords. This is a warranty deed. Okay. Let's do letter C. To have and to hold the above described premises together with all singular the rights and I always have a hard time saying this word, appurtenances thereto in any wise belonging unto said grantee as successors and assigns forever. And grantor does hereby bind himself as successors, heirs until executors and administrators to warrant and forever defend. Okay, here we go. Warrant and forever defend. Okay. Okay. So letter C is definitely a warranty deed. Okay. So one of these three, okay, is kind of tricky. So letter A, for sure, quitclaim deed. Letter C, for sure, warranty deed. But letter B, let's go back to letter B, okay? To sign and forever defend all in singular the property to grantee and to grantee, successor, and signs against every person whomsoever lawfully claiming or to claim the same or any part thereof by, through, and under grantor, but not otherwise. Okay? So look, I'm warranting everything, but only claims by and through and under grantor. Okay? That is telling you, hey, this is a special warranty deed. Okay? He's only saying, look, I'm going to defend you. I'm going to defend this title to what I'm conveying to you. Okay? But I'm only going to do so any claim that is against me. Okay? Not anything else in the chain of title. Okay? See, look at letter C. There's no limitation as to, well, it's just by and through another grantor. This is everything. Okay? So hopefully you're seeing the differences. So A again is quitclaim deed, B is a special warranty deed, and C is a warranty deed. So expressly convey mineral rights. Now, you can, in order to keep it, you have to expressly reserve it, right? But you can convey it too. You can expressly convey your minerals. Like, I'm going to convey to you all my mineral rights. You can do that. So this conveyance is intended and does cover all grantor's rights, title, and interest, and into all oil and gas and other minerals in and under the before described land. So here, this is expressly conveying their mineral rights, and you can do that. Okay. Other means of title conveyance. So you can convey mineral rights via will. So it takes effects on the testator, that's the person who the will applies to, death. So very important that the will is entered into probate. A judge has, probate means a judge has made a ruling that the will is real and valid. Okay, a lot of families contest the validity of the will. Again, they're saying, hey, look, the testator / let's say my grandmother didn't have the mental capacity to, whenever she signed or made this will, or whatever challenges they want to make to the will, because they didn't get what they wanted to get out of the will. Okay. When large amounts of mineral rights or lots of money are at stake, people can contest the validity of a will in hopes that they will get a piece of the pie that the testator didn't, piece of the pie that was not given to them in the will. Okay. Many people own mineral rights, do not specifically devise mineral rights within their will. If this occurs, look at the residual provision of the will. So hopefully everybody in this class has a will. Wills are very, I guess a basic will is very easy to do, depending on how much assets you own. Okay, but wills are not that difficult to put together. But again, it depends on the how much you own, right? Um, okay. So in a part of a will, there's what's called a residual provision. Usually, you can specifically state, okay, I'm going to give my wedding ring to X. I'm going to give, my dresses to Y. I'm giving my car to Z. Okay, those are specific. Okay, but let's say you forgot to mention stuff. Well, there's a provision in your will that states, hey, all the residual remainder will go to X, Y, Z. Okay, so you look through that provision. If certain rights or certain properties were not specifically given to a person or entity. If a person dies without leaving a will, or if a judge declares that the only presented will, meaning this is the will this person left behind, was invalid, most states will apply what's called their intestate succession laws. Now, okay, if you die with a will, it's called died testate. Okay, if you died without leaving a will, or leaving a will that was declared invalid, it's called intestate. Okay, that's the difference. Okay, so here's a chart. This is a chart that depicts what happens during intestate succession. Okay, Texas descent and distribution. So if you don't have a will, or again, a judge says the only will that was provided is not valid, okay, you look at the chart and it tells you, well, who should get what. Okay, it's divided into real property, it's divided into separate and community property. So what did this piece of property, you apply to each piece of property. Okay, so if the property was separate property, the person that died, it was their separate property. It was real property. So what happens? Okay, and this is if they died with children. Okay, you can Google, excuse me, Google Texas descent and distribution to get the full chart. Okay, excuse me, real quick. Thank you. Liens and foreclosures. So people have to borrow money to purchase real property. Okay, companies have to hire other service companies to perform operations on their wells. Okay, so what happens whenever you don't pay back the people you owe money to? Okay, there's a lien foreclosures, right? Title can be acquired through foreclosures of mortgages, deeds of trust, mechanics liens, material means liens, or the lien of judgments. Okay, just know that liens or flash foreclosures is another avenue in which mineral rights can be conveyed, just like a house. So, several of you have either know somebody or have worked for service industries. So, again, I work for a company called Pintail Oil and Gas. Okay, and it's very important that I protect my company. Okay, during any given oil operations, an oil company may have many different service vendors on contract. So when we drill a well, okay, there's a rig company. Okay, they own the rig that drills the wells. There's a mud man. It's not like regular mud that we think of, and we'll discuss this more later on in the chapter. In the semester. But there's so many different parts, some different people that are required in order to drill an oil and gas well. Okay, smart oil companies will demand that the vendors waive and release their rights to liens on the company's property. Okay, so if I failed to pay company X for what they did on this well, what that company is going to do is going to put a lien on that well. Okay, now if there's a dispute, okay, whether they didn't do the job they were paid to do, or there could be a variety of different disputes. Again, you don't want your property, you don't want a lien on your property. Other methods, okay, again, what have we been talking about? We've been talking about deeds, wills, liens, what are we talking about again? We're talking about how mineral rights can be conveyed, okay, or acquired. Okay, so other methods are through tax sales, court decrees, divorce decrees, eminent domain, condemnation, and adverse possession. Okay, squatters. These are other methods in which mineral rights, once owned by person A, can be owned by person B. Okay. Undivided interest. That's very important. Okay, so scenario 1. Let's say Jack and Jill each own an undivided 50% of Hill A. So in this picture, Hill A, representing Hill A, Jack and Jill both own 50%, undivided 50%. This is a very important term that you need to learn when it relating to real property. So, undivided interest. Does that mean Jack owns the west half or the north half, and Jill owns the remaining half? No. They both own an undivided 50%. You can't say, well, anywhere that you point on this hill, anywhere, Jack and Jill both own 50% of that point that you're referring to. Okay, it's not divided. It's evenly spread out throughout that whole tract of land. So Hill A is the tract of land we're discussing. Jack and Jill both, in every point in that Hill A, Jack and Jill both own 50%. Undivided interest. That's what it means. Okay. So the Galleria, Jack and Jill owns an undivided 50% each in the Galleria. Okay. All right. That means in every store you go to, Jack and Jill both own 50%. It's undivided interest. So does this mean that Jack owns the left half and Jill owns the right half of the hill? No. Again, undivided. Undivided is not a physical division of a tract of land. It means a fractional percentage ownership of the entire tract. Okay, moving on. There's different types of ownership. Okay, there's a tenancy in common. Each party, it could be a company, it could be a person, owns an undivided interest in the tract of land. So tenancy in common. So, or tenants in common. Okay, a TIC. Okay, so let's do an example. Let's do me and you. We both own 50% of the Galleria. Again, back to the Jack and Jill example. In every store that we go to, we both own 50% of every store. It's undivided. We're tenants in common. Okay. Joint tenancy. This is a different type of ownership. Similar to tenancy in common, each party owns an undivided interest in the tract. The parties obtain their rights to the tract of land in the same instrument. This is very important, okay? And each party has the right of survivorship to the other share. Okay. Tenants in common. You and I are tenants in common. We own the Galleria. If I die, you don't get the right of survivorship, meaning you survived me, you get my 50%. No, okay? That is not tenants in common. Joint tenants, if we are joint tenants, then yes, if I died, you get my 50%, okay? And in order to be joint tenants, when you obtained your 50% and I obtained my 50%, we did so in the same instrument, okay? Meaning the person that owned it 100% before, in the instrument conveyed 50% to me, 50% to you, okay? So that's joint tenants. That's the rights are different than tenants in common. And the next type of ownership is called tenancy by the entireties. Now, same provision as undivided interest. The parties obtain the right to the tract of land in the same instrument. Each party has the right of survivorship and can only exist between a husband and wife. That's the difference between joint tenants and tenancies by the entireties. Tenancy by the entireties is between a husband and a wife. Okay? And we'll do more examples of this throughout the semester, that when you apply it, you'll be able to learn it better. So let's look forward to week 3. So what are we going to learn next week? Acknowledgments, okay? Why wasn't this listed as an essential element of a deed? Does that mean it's not important to an oil and gas in oil and gas law? Acknowledgement is when you go to a notary public and they watch you sign an instrument and they stamp it and they sign it, saying, hey, look, this is in Texas, saying, hey, look, I saw this person sign it, I verified his identification. Okay, that's called acknowledgement. What is an innocent purchaser? This is very important. Okay, we're going to learn about what is an innocent purchaser. We're going to learn about recording statutes. That's why we have county clerk's offices. Once you get this sheet of paper, okay, this week we learned, hey, look, in oil and gas law, you got to have a sheet of paper. Okay, you have to have it in order for it to be a valid contract relating to real property. Okay, so we're going to learn about recording statutes next week. What do you do with that sheet of paper? We're going to learn about the Louisiana mineral rights and surface rights. It's a lot different. Louisiana is different. It's called Napoleonic law. Okay, it's not based on our common law system. Napoleonic law is different, and we'll discuss the differences. Bundles of sticks. If you own mineral rights, what does that mean? Right to what? What do I have a right to? Okay, I own surface right. So what? What are these rights? So just think of a bundle of sticks. Each stick represents a right that you have, and we're going to discuss each stick. Okay. Mineral interest, royalty interest, and working interest. We're going to learn about those three unique terms as well. Okay. So hopefully I didn't go too fast over this. In week 3, when we have our live class, I'll go through some of these points again. I hope that you all have, depending on when you review this video, have or had a safe and great Thanksgiving. Thank you very much, and I look forward to seeing everyone in week 3. And please feel free to email me at any time. Thank you.